आदरणीय मोहम्मद आरिफ खान साहब, वरिष्ठ अधिवक्ता हाई कोर्ट, आपसे मैं निवेदन करूंगा कि आप आए और आपके टॉपिक को ओपन करें फॉर द डिस्कशन। युवा साथियों से निवेदन है कि जो लोग भी लास्ट में क्वेश्चन आंसर सेशन में कुछ क्वेश्चंस करना चाहें वो लोग अपना नाम लिख करके दे देंगे। आदरणीय मोहम्मद आरिफ खान साहब, जोरदार तालियों के साथ।
My Lord, Honorable Mr. Justice Alok Mathur, the Chief Guest, Honorable Mr. Justice Saurav Lavania, Mr. Rakesh Chaudhary, the President of the Awadh Bar Association, Mr. Amin Nam Tripathi, the Secretary, the members of the governing body, senior advocates, learned member of the bar, my colleague and staff, we are assembled here to discuss the PIL as a tool of judicial activism in enforcing environmental laws. Behind the concept of public interest law lies the special relationship between legal representation and responsiveness of political system. Legal provision is the basic delight of a democratic form of government, indicating that in the governance of law, it is not men, but it is the men of law who govern. Now, as Mr. Tripathi has said, and given the vast concept of PIL, I will try to satisfy. Now, the seed of concept of PIL was initially sown in India by Honorable Mr. Justice Krishna Iyer in Mumbai Kamgar Sangh versus Abdul Bhai. The case is reported in 1976 Supreme Court cases, page 144. After the germination of the seeds of the concept of PIL in the soil of our judicial system, the schedule of PIL was nourished, nurtured and developed by the Apex Court by a series of outstanding decisions in Fertilizer Corporation, Kamgar Union versus Union of India, AIR 1981 Supreme Court, page 344. The terminology of public interest litigation was used and gained momentum day by day and fully blossomed with fragrance smell in S.P. Gupta's case, that is S.P. Gupta versus Union of India, reported in 1982 SCC page 149. As observed by the Apex Court in the case of Janata Dal versus H.S. Chaudhary, reported in 1993 Supreme Court, page 892, that so far as newly founded concept of PIL in Indian legal system is concerned, we can be proud of the same, that there is tremendous development and automatic progress in cosmos of PIL in spite of multiple criticisms leveled against various aspects of the PIL. Now in India, the first public interest litigation case before the Supreme Court was, as you are well aware, I think so, was Hussain Ara Khatun versus the state of Bihar, where the Apex Court gave as many as 4 interim orders regarding the judicial custody of the children. Thus a pattern was set up by the Apex Court in Hussain Ara's case, which has been followed in many later coming public interest cases. Now, after the development of innovative strategy of public interest litigation, the Apex Court tried to remove any possible hindrance that can obstruct the process of reaching justice to poor masses in India. So much so, in order to encourage the vigilant citizens to bring the notice of the court the socio-legal problem of the poor and downtrodden, the higher judiciary in India has been treating even the letters, postcards, telegrams addressed to the judges, the court or the legal aid committee as repetition. This was indeed a unique development that distinguishes Indian judicial system from other judicial systems in the world. Most of the landmark public interest litigation cases have been initiated by writing letters to the Supreme Court, and these letters were treated as writ petition, such as in the case of Public Union of Democratic Right versus Union of India, 1982 Supreme Court, page 1473. And in that case, the letter was initiated, and that was sent by an organization for protection of democratic rights of the people. Likewise, in the case of Upendra Bakshi versus State of UP, 1981, Supreme Court, page 113, and Olga Taylor's case, and various other cases, the Supreme Court has taken the cognizance of even the letters issued by the Organization for Protection of Democratic Rights. There has been general procedural objection that letter addressed to the court by a party cannot be treated as a writ petition for the enforcement of the fundamental right under Article 32 of the Constitution of India. Now, this objection was ruled by the Apex Court in the case of Bandhua Mukti Morcha case, wherein the Apex Court has observed that though normally the procedure prescribed in the court rules was desirable to be followed while entertaining a petition, but in exceptional cases where general public interest was involved, the court might exercise its jurisdiction under Article 32 of the Constitution of India for enforcement of the fundamental right, treating the letter or the communication in any other form as appropriate proceeding. Now, the law is now well settled that a very weaker section of the community are concerned living in poverty and destitution, in miserable condition, helpless victim of an exploitative society, not having access to the judicial system, the Apex Court could not insist on a regular petition to be filed. This position was clarified in the case of Himachal Pradesh versus a parent of a student of Medical College Simla, wherein it was observed that every letter may not be treated as a writ petition by the Supreme Court and the High Court. It is only where the letter is addressed by aggrieved party or by a public respected individual or a social action group for vindication of the constitutional or legal rights of the person who by reasons of poverty, disability and socially or economically in a disadvantageous position find it difficult to approach the court for redressal, the court should be justified and will be bound to treat the letter as a writ petition. Now, in the case of Mukesh Advani versus State of Madhya Pradesh, reported in 1985 Supreme Court, page 1368, the Apex Court even accepted a newspaper clipping narrating a short story about bonded labor as basis for public interest petition. Thus, various honorable judges have initiated public interest litigation in the interest of justice. Now, so far as the present topic for which we are assembled here, that is in the environmental law, also the judiciary has played active role to protect the humanity against adverse effect of environmental pollution and ecological balance. The reason was that the pollution problems threatens the every survival of human race. Article 47 capital A directs the state to endeavour to protect and improve the environment and to safeguard the forests and wildlife of the country. Article 51A class G enjoins upon every citizen the fundamental duty to protect natural environment. As you are well aware, there are laws to this effect, that is Water Prevention and Control of Pollution Act 1974, Air Prevention and Control of Pollution Act 1981. But despite all these acts, the Bhopal tragedy case, as you are well aware, had occurred. Now, in the case of rural litigation and entitlement of Kendra versus State of UP, popularly known as Lime Quarry case, reported in 1985 Supreme Court 85865, the rural activist group filed a writ petition in the Supreme Court based on Article 21 and 48A of the Constitution of India that limestone quarry that was causing irreparable damage to hillsides, villages and surrounding farm land in Doon Valley, and that was the first case of its kind involving issue relating to environment and ecological balance, and therefore the question arises for consideration was of great significance to the citizen of India. This case shows concern of the court for the health and environment of the people who were not even parties to the petition, and shows a demonstration of readiness on the part of the court to intervene in the matter which have been forbidden areas of the court in India. Likewise, in MC Mehta versus Union of India and Shri Ram Food and Fertilizer versus Union of India, a writ petition by way of public interest litigation was brought and raised similar question concerning the true scope of Article 21 and 32 and the principle and norms for determining the liability of large enterprises engaged in the manufacture and sale of hazardous products, the basis on which the damages in the case of such liability should be qualified. The Apex Court held that enterprise must be held to be under an obligation to provide that hazardous and inherently dangerous activities in which it is engaged must be conducted with the highest standard of safety, and if any harm result on account of such activity, the enterprise must be absolutely liable to compensate for such harm, and it should be no answer to the enterprise to say that it had taken all reasonable care and that after the harm occurred without any negligence on its part. After the Bhopal Gas Tragedy disaster case, the Apex Court had really awakened the people to be conscious of protecting their environmental rights, and the writ petition filed under Article 32 by a public spirited man of Tehri Garhwal and Uttar Kashi against the UP government decision to construct Tehri Dam on Bhagirathi as arbitrarily unreasonable and destructive of lives and property of thousands of residents of Garhwal. Now again, you will find in the case of MC Mehta, first case versus Union of India, reported in 1987 for SCC page 462, wherein a PIL was brought to enforce citizens' fundamental right to clean and hygienic environment which was being violated by pollution of river Ganga. The Apex Court issued directions with regard to the industries in which the business of tanning was carried on at Jajgaon near Kanpur. Now in the case of Kinkari Devi versus State of Himachal Pradesh, reported in 1988, Himachal Pradesh page 4, wherein the petitioner sought judicial intervention for cancellation of mining leases for excavation of limestone from the hills. The court criticizing the act of government in granting of mining leases to the contractor without any regard to the life, liberty and property of the people residing in the area, issued several directions to the state government for protecting Shivalik hills. In the case of LK Kulwal versus State of Rajasthan, reported in 1988, Rajasthan page 2, the High Court at Rajasthan, after interpreting Article 51A as conferring a constitutional right to the citizen to approach the court for enforcement of the duty cast on the state to protect environment, and the Rajasthan High Court had given an altogether new interpretation by converting a fundamental duty into fundamental right for the enforcement of constitutional duty. Likewise, in the case of Goa Foundation and others versus Konkan Railway Corporation, reported in 1992, Bombay, page 471, it was observed that in fact no development is possible without having some adverse effect on the ecology and environment. But the project of public utility cannot be simply abandoned, and it is necessary to balance the interest of people as well as the necessity to maintain environment. The preservation of human life is the paramount importance, because once life is lost, it is not in the capacity of man to restore it. The famous case of T.N. Godavarman Trimul Park versus Union of India, which is a landmark case, is also known as a forest case in India, It was regarding the control and supervision of the forest in India. The main objective of the writ petition was to safeguard and protect the forest land of Nilgiris as it was exploited through deforestation by unlawful timber activities. The Apex Court issued directions to use the forest and its resources sustainably as also a self-monitoring mechanism. It deals with the environmental rights of all and also the intervention of the court. A ban on the felling of the trees, regulating the industries, the prohibition of the mining and regulation of the sawmills was issued by the Apex Court so as to protect the environment. In the case of Hinchalal Tiwari versus Kamla Devi and others, reported in 2001 volume 6 SEC page 496, the Apex Court has gone to hold that the material resources of community like forests, tanks, ponds, hillock, mountain, etc. are nature's bounty. They maintain delicate ecological balance. They need to be protected for a proper and healthy environment which enable people to enjoy quality life, which is the essence of the guaranteed right under Article 21 of the Constitution of India, and issued directions to restore the ponds after demolishing the constructions and maintain the same as a recreational spot which will undoubtedly be in the interest of the villagers, and further it will also help in maintaining ecological balance and protecting the environment. Now, as our secretary has said in the beginning, that for maintaining a writ petition, two, three things are most important. That is the locus of filing a writ petition, which has been diluted by the Apex Court by entertaining the writ petition, that is the letters, newspapers, and even the newspaper clippings have also been taken into consideration while issuing the writs. So the scope of PIL is now not narrow, and if the court finds that by the action or inaction of the state authorities, there is a loss of environmental pollution, etc., the court in appropriate cases can issue writs. Now, so far as the formal manner is concerned, after the first case of Hussain Ara, as I had told, Justice Krishna Iyer had sown the seed of the PIL, which has subsequently grown and flourished, and now in the present era, we are dealing with the PIL. But when this PIL was used as a tool for personal grudge, the Apex Court has also put certain restrictions that by means of it, and as you have seen from the rules of the court, of this court, a declaration is required to be given while filing a petition that you have got no interest, personal interest in the matter, and then the petition will be entertained. So for the locus, the question which has been posed by the secretary, the principle of locus has been diluted insofar as the PIL is concerned. And the court, while passing the orders in PIL, has to first satisfy as to whether the writ petition has filed not by a body of busy persons for redressal of their grievance. It is the interest of the public that has to be considered while entertaining the petition, that is PIL petition. So in nutshell, this is the scope, ambit and power of this Honorable Court as well as the Apex Court, which has been exercised in PIL matters. And in so many cases, the Apex Court entertained the PIL petition, but had also imposed a restriction, as I have said, that by filing frivolous petitions, the precious and valuable time of the court should not be wasted, and that's why a check has been placed while entertaining the writ petition. So in nutshell, this is the scope and ambit of the PIL, the locus, as well as the person who can approach this Honorable High Court as well as the Apex Court by filing the writ petition. That's all.
थैंक्स अ लॉट। आदरणीय मोहम्मद आरिफ खान साहब, एक बार फिर से जोरदार तालियों के साथ आपका धन्यवाद। जैसा कि आदरणीय खान साहब ने बताया, मुसर्रा खातून के जजमेंट से आपने जस्टिस कृष्णा अय्यर के बारे में बताया, हु इज सेड टू बी द फादर ऑफ पीआईएल्स इन इंडिया। आपने बताया कैसे माइनिंग को रेगुलेट करने के लिए पीआईएल में कोर्ट्स ने ऑर्डर्स किए, एयर पॉल्यूशन को कंट्रोल करने के लिए दिल्ली में एनसीआर रीजन में कोर्ट्स ने इंटरवीन किया, पराली बर्निंग को लेकर के कोर्ट मॉनिटर्ड ऑर्डर्स हुए, उससे उसको कंट्रोल करने की कोशिश हो रही है। इवन चर्च ऑफ गॉड के केस में जब ऑनरेबल सुप्रीम कोर्ट ने नॉइस पॉल्यूशन के मेनस को देखा और उसमें ऑर्डर्स किए, तो उसमें नए एक्ट और रेगुलेशंस बने हैं। एक्ट में आपने बताया कि किस तरह से कोर्ट्स लेटर पिटिशंस को और सुओ मोटो कॉन्विनियंस लेकर के किस तरह के कोर्ट के रूल्स को रिलैक्स करके पिटिशंस इंटरटेन की गई। जनरली कोई भी पिटिशन मेंटेन करने के लिए कोर्ट के जो रूल्स होते हैं फाइलिंग के, टिकट का, 50 तरह के डिफेक्ट्स हम लोग रोज फेस करते हैं रिट फाइलिंग में। बहुत सारे पीआईएल्स में वो रिलैक्स करके भी कोर्ट इंटरटेन्स करती हैं। खुद सो मोटो न्यूज़पेपर की रिपोर्ट्स को सो मोटो कॉन्विनियंस लेकर के रिपोर्ट मैटर इंटरटेन होते हैं। धन्यवाद आदरणीय मोहम्मद आरिफ खान साहब, आपने